Trump's arrest tomorrow. His most loyal allies are attempting to downplay the incriminating indictment, including, of course, House Judiciary Committee Chairman Jim Jordan.
The standard is clear. The standard is Navy versus Egan, a 1988 case, unanimous decision from the court that Justice Blackmun wrote the opinion. And it said the president's ability to classify and control access to national security information flows from the Constitution. He decides. He alone decides. He said he declassified this material. He can put it wherever he wants. He can handle it however he wants. That's the law.
Now, it is true that that suddenly oft-cited 1988 Supreme Court case does say it is the sitting president's authority to, quote, classify and control access to information bearing on national security, unquote. But there are a few issues with what the chairman there is saying. First of all, Navy versus Egan isn't really a case about a president's authority to declassify documents. That sentence is merely background in a case about a Navy contractor who lost his job because his security clearance had been revoked. And that narrow case is what the court decided on unanimously. And perhaps more importantly, Chairman Jordan conveniently glossed over the damning evidence that suggests that Mr. Trump knew he could, but did not declassify these documents while he was president. There's no evidence that we've seen at all that he declassified any of these documents while he was president. Let's talk about this and other defenses with CNN legal analyst Carrie Cordero and former Watergate prosecutor Nick Akerman. Nick, let me start with you. What do you make of this Navy versus Egan argument from the chairman there?
It has absolutely nothing to do with Trump's situation. All it stands for is this poor guy, Egan, who had a criminal record and a drinking problem, was denied a security clearance to work on the Trident submarine program. It has nothing to do with what Trump did. In fact, what it does say, it warns about giving untrustworthy people access to classified information, which applies in spades to Donald Trump. I mean, if you look at what he did with this material after he was president, that he held on to it when he had no right to do it, that he basically put it in his barroom, in his bathroom, and in his living quarters, and essentially lied and orchestrated a cover-up to keep the government from getting this material back. This case has absolutely nothing to do with any of these issues. In fact, it wasn't even unanimous, Jake. I think it was like there's 4 dissents in the case, but it all has to do with whether or not this poor guy who couldn't get a security clearance could appeal it to a special board.
Carrie Cordero, let's talk about Republican Senator Lindsey Graham of South Carolina. He took a different route in trying to defend Donald Trump. Take a listen.
You got vice presidents, secretary of states, and presidents handling this stuff. You had Bill Clinton with tapes in his sock drawer. I would like to review the system, but here's the point I'm trying to make. I think the espionage charges are completely wrong, and I think they paint an impression that doesn't exist. This is not espionage.
I mean, these are lawyers, so I mean they know what they're saying is crap. But explain to us about the Espionage Act.
Right. Okay. So there is a set of statutes under federal criminal law, generally known as the espionage statutes. Within those, and those are the statutes under which individuals who actually engage in espionage, spying for foreign governments, that is the set of laws that they're charged under. It also has the set of provisions of law that individuals who are charged with mishandling classified information, or in this case, willfully withholding national defense information, are also charged. It's interesting, the argument Senator Graham makes. Sometimes there are individuals, defense attorneys or individuals who are whistleblowers and reveal information to news sources who later argue that this type of mishandling or turning over classified information shouldn't be prosecuted under the espionage statute.
And that's a legitimate argument.
And so that is an argument that some in the legal community or the advocacy community make. But in this case, former President Trump hasn't been charged with spying for a foreign government or espionage as we normally think about it, but he has been charged with willfully withholding national defense information, which is the way that a case like this is normally charged.
I mean, these very weak and misleading arguments right out of the bat by Lindsey Graham and Jim Jordan would seem to suggest they really don't know how to defend this, if at all.
Well, and there is no one arguing that a president, going to Jim Jordan's points, nobody is arguing that a sitting president, doesn't have the authority to classify information. Like, there is no argument in the legal community about that it's commander-in-chief authority. The difference here is that there's no evidence it ever happened.
And Nick, there seems to be a pattern emerging of Trump's own lawyers leading investigators to key information. You had the Manhattan indictment with Michael Cohen. Now you have Evan Corcoran. Now you say Corcoran was probably the source of the search warrant after he realized he was being played by Trump. That's a theory. We don't know that as a fact as of now. But how?
Well, I think I'm right because there's no other way. First of all, to put that into a search warrant, the probable cause for this obstruction had to come from an inside witness who laid it out. You don't conduct a search on a former president's residence without having a real solid probable cause. You're not going to put in circumstantial evidence. And certainly Corcoran was in a position where he had to realize at some point that there were 30 boxes that were hidden from him that he didn't get to look at. And so he is the logical person that was the inside source that gave this to the FBI. And I might also add, in terms of lawyers and the reaction to Trump and what they've done, you've also got John Eastman in the Georgia case, who also had one of his emails produced to the January 6th committee because of a statement in furtherance of a crime as opposed to attorney-client privilege, where he admits that Trump knows he's filing an affidavit in federal court in Georgia that's full of lies about the election being rigged. So we do have this pattern running throughout these cases where one of the chief witnesses against Trump in each of these cases is really his own attorneys.
Nick Akerman, Carrie Cordero, thanks so much. Appreciate it. Coming up, Republican lawmakers